Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on the doctrine of self-incrimination. It has come in Hindu that the Special Court for Terrorist Activities, Spl.Judge V.R. Kachri of Pune, he denied the application or the petition of the Maharashtra Anti-Terrorism Squad, that is ATS. He denied the application of ATS, which requested the judge to allow the so-called scientist, a DRDO scientist, to undergo the polygraph test. Why? This is important. First of all, basically, this DRDO scientist, he was arrested in a honey trap case. That means he was trapped by a Pakistani agent, maybe for money, maybe for sex and other things. And he has passed on the confidential information of our country, India, to Pakistan. So he was arrested by Maharashtra ATS people. And they wanted to know other details from him. What is his psychological condition? So they wanted to subject him for polygraph test. Then polygraph test number 1. Second is psychoanalysis or psychological analysis test and voice layer test. These are the T tests. So they have filed a petition, and as usual, notice was given to the other party. That means the scientist. The argument on behalf of the scientist, the advocate, clearly argued and cited the very famous case of Selvi versus State of Karnataka 2010. Doctrine of self-incrimination under Article 20, Clause 3, Article 21 of the Constitution of India also. In the case of Selvi versus State of Karnataka, Honorable Supreme Court of India clearly stated that if the person is not willing to undergo the so-called psychological test, then you cannot force him because it amounts to testimonial compulsion or the doctrine of self-incrimination. Finish. But is it that necessary? Suppose if the psychological test or if the polygraph test is 100% necessary, what the court has to do? This is also another question. For this, I want to give an example. A murder case took place in Kakinada, maybe in the year 2008. So there we have suspected one person as an accused person. So we have been interrogating him. He is not telling, he is saying that he is totally innocent, he has not committed. But all other fingers are poking towards him. Other witnesses, they are saying that, sir, just we have seen him, he is coming from outside. Then when we suggested him to, why don't you go undergo the polygraph test? Then he said, okay, because the truth will come out. In such cases, yes. In such cases, yes, the polygraph test can be allowed. And we allowed him, and even in the polygraph test also, he came out successful that he has not committed the offense. So in such cases, only the polygraph test is allowed. Basically, polygraph test or psychoanalysis test or voice layer test, all of them, they are just useful aids for the investigation. They themselves are not confirming evidence. They are just useful aids for the police investigation. Basing on that, they can probe further. So please remember, only basing on the psychoanalysis test, you cannot file a charge sheet. The police cannot file a charge sheet against a person. This is what they have to learn. So please remember here, Honorable Justice V.R. Kachri, Special Judge, he has refused to refused to give permission for the ATS people for conducting the polygraphy, voice layer and psychological analysis test. Why? Because it is crystal clear and there are so many clear and well settled law. It is very crystal clear and there are well settled laws that no individual shall be subjected to the test, so-called polygraph test, forcibly. If he is willing, okay. Just now I told you the Kakinada case. So he has, of course, better you know the Selvi case, Selvi versus State of Karnataka 2010. So employment of neuroscientific tests constitutes the so-called testimonial compulsion. It is violation of Article 21. Another case, Sharma versus Satish Chandra, Madhya Pradesh, 1954. At the point itself, the so-called test, the person should not be unnecessarily subjected to the so-called testimonial compulsion. So very simple issue. Please remember, without permission, without concurrence, without agreement from the accused party, the court cannot subject him for the polygraph test. If you know this much, this is sufficient. Selvi case is a very important case. So incidentally, it has come in the press. So please remember the case law. Thank you.